Okay, so here we are dealing with UCC, that is a recently a private member bill titled Uniform Civil Code in India was introduced in Rajya Sabha. So the bill that seeks to provide a panel to prepare a UCC to be implemented across the country. Here UCC refers to the same set of civil laws that are applicable to all the citizens of India and in their personal matters such as marriage, divorce, custody, adoption, inheritance. These all are the part of the UCC. So the provision of Uniform Civil Code that is come under Article 44. Here DPSP, it is come under the DPSP. It says that all states shall endeavour to secure a UCC for citizens throughout the territory of India. And the UCC that comes under justiciable part of the constitution. Also the personal law comes under the concurrent list. So the current status of personal laws in India, it is that as different religious communities are currently governed by a system of personal laws which have been codified over the years and through various pieces of legislation. For example, Hindu personal law is codified in 4 bills like Hindu Marriage Act, Hindu Succession Act, Hindu Minority and Guardianship Act, and Hindu Adoption and Maintenance Act. So marriage, succession, minority and guardianship, adoption and maintenance. So these Hindu includes Sikh, Jains, Buddhist for the purpose of these laws. So certain aspects of Muslim personal laws are expressly recognized in India in such acts such as Shariat Application Act and Dissolution of Muslim Marriage Act. So Christian marriages and divorce are governed by the Indian Christian Marriages Act and also the Indian Divorce Act, with while Zoroastrian are subject to the Parsi Marriage and Divorce Act. So there are some secular laws as well. For example, if we talk about Special Marriage Act, under which interreligious marriages take place, and the Guardian and Ward Act, which establishes the rights and the duties of guardians. And Goa at present is the only state in India with have a uniform civil code. The Portuguese Civil Code of 1867, which continues to be implemented after India annexed the territory in 1961. So it applies to all Goans, irrespective of their religion, ethnicity, community. So, however, Portuguese code is not completely a uniform civil code. It makes certain provision on religious basis. For example, if we talk about Hindu men are allowed bigamy. If I fails to deliver a child by age of 25 or a male child by age of 30. So a need of UCC, that is gender equality, like personal laws becomes, because they derived from tradition and customs, also tends to give undue advantage to men. Law Commission's 2018 observes that various aspects of prevailing personal law disprivilege women. For instance, Muslim men being allowed to marry multiple wives, but women being forbidden for having multiple husbands. So, despite the 2005 amendment of the Hindu Succession Act, women are still considered part of their husband's family after marriage. So, in case of Hindu widows dies without any heirs or will, their property will automatically go to her husband's family. So, men's, that means fathers, are also treated as natural guardian and are given preference under the Hindu Minority and Guardianship Act. To address this inconsistency in personal laws, there is no consistency in how issues like marriage, succession, and so on are treated to people belonging to different communities. Reforms to the personal laws have also been inconsistent. For example, if we talk about Muslim amendments, they have been brought to Hindu personal laws, while Muslim law has seen fewer changes. A secular republic aspires for common law for all citizens rather than differentiate rule based on religious practice. So, simplification of laws, like when enacted, the code will simplify the complex law around marriage, ceremonies, inheritance, succession, adoptions, making them one for all. Uh, the same civil law will then be applicable to all citizens irrespective of their faith. Okay, so it will reduce the burden on judiciary due to standardization of personal law, and also it enables for speedy delivery of justice. Also, it protection of vulnerable section to the society, like UCC aims to provide protection to the vulnerable section of the society. Vulnerable sections such as envisaged by Dr. B.R. Ambedkar, including women and religious minorities. Now, arguments against implementation of UCC, like diversity within secular civil laws. Like, while India does have uniformity in most criminal and civil matters, like civil procedure code, etc. States have been several amendments to civil wars. So, civil laws, like for example, law of anticipatory bail differ from one state to another. Also, expert cites plurality in already codified civil and criminal laws while arguing against UCC. So, looking at the codified personal laws of various communities in India, all Hindus are governed by a homogeneous personal law even after the enactment of the four acts. So, communal politics, like large section of society, sees it as majoritarianism reform in several verdicts, like S.R. Bommai. Supreme Court has warned against mixing politics with religion. So the court had worried whether a secular state should bring a code which can be perceived as a threat to personal law based on religious beliefs. So, against the diversity, unified nation does not necessarily need to have uniformity. Efforts have to be made to reconcile our diversity with universal and undisputable arguments on human rights. So, the term secularism that has meaning only if it assured the expression in of any form of differences, that is diversity, both religious and regional, should not get subsumed under the louder voice of majority. So, it can erode minorities' right. Also, though UCC reinforces equality before law, it also clashes the right to freedom of religion, Article 25. Okay. So the UCC could become a tool to erode this right, surpasses minorities and homogeneous culture. So it is not supported by law mission. So in 2018, what has happened? The Law Commission and consultation in a consultation paper held that UCC is neither necessary nor desirable at this stage. So we need to follow the collaborative approach here. There is a need to build a consensus among all the stakeholders and educating the individuals regarding their true nature and positive effect of the UCC. Brick by brick approach rather than omnibus approach, the government could bring separate aspects such as marriage, adoption, succession, and maintenance into a UCC stage. Also, the goal of a UCC should ideally be reached in piecemeal manner, like the recent amendment on the age of marriage. A just code is far more important than a uniform code. Also, the Law Commission recommendations that in absence of consensus on UCC, the Commission felt that the best way forward may be to preserve the diversity of personal laws while ensuring that they do not contradict fundamental rights. In order to achieve this, it is desirable that all personal laws relating to matters of family must be codified to the greatest extent possible. So this will limit the ambiguity in interpretation and application of all these personal laws. Also, the Commission has suggested a range of amendment to existing family laws to address various inequalities. Also, the legislature should first consider guaranteeing equality within communities between men and women rather than equality between communities. Also, this way, meaningful differences within personal law can be preserved and inequality can be weaved out without any absolute uniformity. So, we have another topic, that is right to vote for under trials. Okay, and then initiative launched under e-court project, then Aadhaar rules, then police commissionerate. So all these topics we need to complete. Here first we go with the right to vote for under trials. So here Supreme Court has decided to examine the law depriving under trials the right to vote. Here decision in the examine came on a petition challenging section 62 of subsection 5 of the Representation of People Act. Here it deprives prisoners to the right of vote. So this restriction does not apply to a person under preventive detention. Okay, according to the latest National Crime Reports Bureau, there are around 5.5 lakh prisoners in the various jails across country. Here, argument supporting in this favor that Article Section 62 subsection 5 of the Representation of Peoples Act is discriminatory because of its broad language, which denies the right to vote even to those detained in civil prisons. Okay, and considered unreasonable for as a convicted person allowed to vote if on bail, while denying this right to even under trials if in prisons. Right to vote is cornerstone of a democracy, so it has to give in to such person. Now, what all are the against argument in this case? Like in Ankur Chandra, Anukul Chandra Pradhan versus Union of India. Here, Supreme Court upheld the constitutional validity of this section. Here, right to vote is not conferred as per Article 14, which is right to freedom. So, here, right to vote is subject to the limitation imposed by the legislature. Here, it helps to avoid the criminalization of politics and also maintain elections integrity. Also, resources crunch such as permitting this would require greater security arrangements. We have another topic, that is initiatives launched under e-court project. Your newly launched projects include virtual justice clock. Here exhibit vital statistics at court level, giving the details of the cases instituted, cases disposed, the pendency. Here Justice Mobile App 2.0, that is tool for judicial officer for effective courts and case management by monitoring pendency and disposal of cases. Here digital court, that is initiative to make court records available to the judge in digitized form to enable the transition to paperless courts. Here S3 was website to generate, configure, deploy and manage websites for publishing specified information and services related to district judiciary. Now, eCourt Mission Promote Project 2007 is a national e-governance project for ICT, that is enablement of district and subordinate courts. Here it was conceptualized based on the report submitted by E-Committee. Here, Supreme Court of India, E-Committee is a governing body that is headed by Chief Justice of India. And also benefit of E-Code, like it make functioning of the court accountable and transparent. It is effective management of court in cases bringing down of pendency. It will make the justice delivery system affordable, accessible, and cost effective. And other initiatives like National Judicial Data Grid, NGT virtual courts live streaming proceedings, and so on. Here, Police Commissionerate. It is the last topic for the November in polity, like Agra, Ghaziabad, Prayagraj to get Police Commissionerate system. Means UP. Here, decision to set up Police Commissionerate system has been taken due to increase in population, religious and cultural significance, tourism, provide better policing and maintain law and order. District would be declared as metropolitan cities as per the rules of CRPC before implementing Police Commissionerate system. Earlier, Lucknow and Noida was adopted Police Commissionerate system, followed by Kanpur and Varanasi. Here, Police Commissionerate system means like it commissioner of the police is head of the unified police command structure, is responsible for force in city and is accountable to the state government. Here, commissioner of police is drawn from deputy inspector general rank or above, is assigned by special joint additional deputy commissioners. Such police officers have the power of preventive arrest, imposing section 11144, that is कि 5 से ज़्यादा collect नहीं होना है, CRPC and initiate chapter proceeding. And also office also has magisterial power, including those related to regulation, control and licensing. Now, various commitments constituted to suggest police reforms have recommended. Here, Police Commissionerate implementation in cities which have population of more than 10 lakhs, which already it surpasses that particular criteria. So, dual command system. Here, district magistrate and superintendent of police share powers and responsibilities in a district. Here, DM is entrusted with issuing arrest warrants, licenses, while SP has the power and responsibilities to investigate crime and make arrests. Here, system is designed to ensure lower concentration of power and making police more accountable to the DM at district level. Aadhaar updated rules. Here is government has amended Aadhaar rules that is specified and that supporting documents may be updated at least once by Aadhaar holders on completion of 10 years for enrollment date. Updation would ensure continued accuracy of Aadhaar related information in CIDR. Here it's centralized database containing all Aadhaar numbers issued to Aadhaar holders along with corresponding demographic and biometric information of such individuals. Rule of law. So they have 10 years thing they have been implementing here again, which has already been passport के case में भी होता है. And Rule of Law Index 2022. Here, World Justice Project that released Rule of Law Index 2022. Here, the World Justice Project is an independent, multidisciplinary organization working to create knowledge, build awareness, and stimulate action to advance the rule of law worldwide. What all are the key highlights of rule of law? Rule of law has declined globally for fifth year in a row. India has been ranked 77 out of 140 countries, so it topped by the Denmark. As per the World Justice Project definition, the rule of law is durable system of law, institutions, norms, and community commitment that delivers the following universal principles: accountability of the government as well as private actors under the law. Just law like law which is clear, publicized, stable, and applied evenly and ensured rightly. Open government here. It is accountable, just law, open government, and accessible and impartial justice. Fair and efficient. Thank you.